So that's where, folks, we want to be starting. If we want to go forward with learning from GTEN, we want to be starting. They're recommending that we start with the private trust education, because this is very foundational, right? This, like you said, this is the main crux of what you guys are putting out.
Mm-hmm, mm-hmm. Just that series alone is well over, I believe it's like 24 hours of wonderful information and dedicated understanding. We walk through the entire Private Express Trust. You get a clear understanding of what it is, how to operate as a trustee. We really cover some great stuff. So.
And right, we provide sample trust documents too. So you will have everything you need to set up a Private Express Trust and the knowledge to operate it without entering federal jurisdiction.
Exactly. When you sign up, you receive access to a Private Express Trust. It is your own Private Express Trust that you can create for yourself. It's a great sample. There are over 200 documents that accompany that to help you operate and administer that trust. And it is a full-fledged trust. So it has all of your articles, all of your bylaws, your minutes, your resolutions, everything.
Exciting stuff. And yes, I've been looking over it often, almost every day. And so I've looked at one of the homework assignments, some of the reading you guys recommend, and this one is Carlton Weiss on Express Trusts. And I thought it'd be interesting to kind of point out two parts of this read that I find extremely interesting, because I've been down and am down both of these paths, have been and still am in some ways, down both of this path of being claiming a sovereign and secured party creditor. And so in this essay, if you will, he kind of tells it like it is with each one, and has certainly made me rethink if I want to consider myself either of those things. Anyway, I'll read a little bit about what he says, and then I'd like both of you to afterwards give commentary and opinion, and also share about your personal experiences that lead you to conclude what you do now about what he's talking about. So this section is called Trustees in Commerce, A Way of Life. This is part of the GTEN.org homework when you enroll for the private trust education. All right, Trustees in Commerce, A Way of Life. This is Carlton Weiss speaking now. He says, a while back I was asked to write a few paragraphs on the specific advantages of living your life as a trustee in everything you do, as opposed to as a sovereign or secured party. I was asked to cover all related bases that included a comparison to show how each choice would hold up in commerce. Again, the choices are trustee in everything you do, sovereign or secured party, right? He was asked to do a comparison and show how each choice would hold up in commerce. He says, what I came to realize is that there is only one way of life in its own category that enhances all others. All the others are actually disadvantages in commerce. He says, at that time, I had just developed a surefire way of piercing pure trusts, and I was on my way to finally uncovering the pivotal flaw in federal contract trusts. What my clients were asking from me at the time was a technology that would allow a statutory entity like an LLC to sniff out minimum contacts people had that bound them to legislative jurisdiction, which would obviously allow the client to overcome the burden of establishing jurisdiction in their lawsuits against those people. I had no guilt about this because my philosophy is that ignorance is never an excuse. Equity compels performance regardless. Here's where he points to what I was just mentioning before. I only assisted with cases that involved people claiming to be sovereigns, secured parties, general managers, managing directors, and other players and entities like pure trusts, federal contract trusts, and corporations sole. In each instance, there was always a common theme, contradiction. Every single one of the people I cracked had contradicted themselves by their stated position compared to their actual position. Every single one of the non-statutory entities I helped pierce was a contradiction by its intended nature and its actual nature. He says sovereigns were nothing more than cestui trusts or beneficiaries. Secured parties were nothing more than people with split personalities reflected in a commercial recording. Even though I understand where they went wrong, the way they went about it was so rife with contradictions, you got the sense they had a screw loose. They couldn't really be helped because they wanted to be respected as creditors when it suited their needs. yet they wanted to be absolved of liability like wards of the court when the pressure was too much, right? So now he goes on with this. Then he breaks it down even further. He breaks down that in order to actually be a sovereign, today, you need a plot of land that you have absolute title to, a fortified compound, a militia to protect it and protect the land, workers to maintain the compound and land, a stockpile of weapons, a stockpile of coin, gold, and silver, full understanding of many different types of law as it pertains to sovereigns and trustees. So, can any of us really live up to that? I don't know about you, but I don't have a castle, or a land or a militia or anything like that. So maybe that stance then is not necessarily what we want to be going for.
Yeah, then if you don't feel like having your property usurped, you're going to have to form a treaty too.
Right. And hopefully you have more weapons than any, would-be conquerors. So, and then he goes into the secured party. He goes on to say, says a UCC financing statement is a very mighty financial instrument indeed, but only when used for the right situation. And then so he goes on to kind of rip into this a little bit. And, he's just saying it's not really, going to work for you all the time. He's saying what you really want to be doing is if you're not happy, he says the simplest way to, fix the problem is just to pull out. If you don't want the benefit, then reject it. He's even saying that it's a benefit on the part of the Secretary of State to publish the UCC-1. So he's saying that we're accepting a benefit when we do that, and he's calling it fraudulent. So very interesting stuff. What do you guys think about that?
That's great. I think the first thing that we might want to let the listeners know is that Carlton Weiss's job was to rip apart people's asset protection. Like before he became an author and proponent of the Private Express Trust, and his books on that, his job was to pierce organizations. He came from an amazing vantage point to understand what works and what doesn't, because he could rip apart anything. A corporate soul, a corporation, a Delaware corporation, a Nevada corporation, an Arizona corporation, a Wyoming corporation, it didn't matter. All forms of statutory trusts, all forms of business associations. His point is that all of them could be pierced, except the Private Express Trust. And, so that background, I think, is interesting to note, because he's now talking about how the Private Express Trust is the way to go. And, absolutely, I agree with him, and we've looked at all of those entities as well. It's pretty clear that they all give jurisdiction in some way, if not in the paperwork, later in the execution, in the administration of the organization, jurisdictions given by minimum contacts or in some other way. And there's all sorts of conflicts in the secured party thing. We've talked about that a little bit in court, trying to not be the name, be the sovereign or the secured party. It leads to a difficult place with any of those forms of organization, for logistics and operations, as well as for asset protection, and they're all pierceable except for the Private Express Trust.
What would be a minimum contact? Like, let's say the Private Express Trust, if the trust, let's say, was to get a library card from a public library, would that be minimum contact that would open up the trust to be pierced and allow the corporate government to have jurisdiction over the trust?
Well, since we're talking about Weiss, I'll just give what he describes minimum contact as, and it's having sufficient dealings or affiliations with the forum jurisdiction which make it reasonable to require the trust to defend a lawsuit. Okay, now if that trust had obtained a library card took out the benefit and privilege of renting books and did not bring them back, then you may be subject to a lawsuit, and it's definitely obtained a jurisdiction that could that could allow that to happen. So
see
yes.
this? I mean, so a library card, people, like this is what we're talking about. Just, things that we've been just normal, the normal order of things that we've been doing growing up. I never would have thought that, having a library card would opt me in to U.S. citizen status or at least the implied obligations that come along with that. I mean, that's kind of nuts, but you know what? This is what's going on. So little things like that we need to be aware of.
Definitely. And I think that's why we developed our next set of series, is so that we can start to, clarify the contracts and the security agreements that exist between entities to allow an interface from public to private and back. Mm-hmm. So we want to maintain that minimum contacts. We want to maintain that minimum, if not completely eradicated, liability of the trust assets when doing business in the public. And the way to do that is to maintain separate entities or special purpose vehicles, and to maintain contracts between those trusts and those special purpose vehicles. The series coming up that we are giving with our private trust education is going to be covering all of the public entities that one would perhaps operate in the public, whether it be for-profit or non-profit. We'll be focusing mostly on exempt organizations, which is the title of the series. And the exempt organizations that we're talking about are anywhere from basically any non-profit that exists all the way into not-for-profits, unincorporated associations, corporations, sole, just about anything you can think of. We're going to be covering all aspects of those entities to understand how they are created and how they are established and how they are administered and how they are used in conjunction with the Private Express Trust as well as other interfacing trusts. We have what's known also as pass-through trusts and things like that, holding trusts. These are all legitimate items. The Trust Web Structure series that we will be covering will get deeper into the contracts between the entities, allowing people to understand the security agreements and the lien rights that actually exist. Like Weiss said here, the financing statement is very powerful as long as it's being used legitimately. The contract is impenetrable, and the private contract between trustee and trust is actually protected under Article 1. So, I mean, there's just crazy things that go on that we need to understand. And there's so much that we decided to break it up into several different parts so that we could clarify what each entity does, what each contract does between the entities, and how they can be used to better the world, and of course how we can operate with them further, which of course is the private banking and lawful money, and that's going to be the topping on the that'll be the cherry on the sundae there. So we won't even get into that because that's a good one there.
That's a big cherry.
It's a big cherry.
Really exciting stuff, man. And so I'll just in my own words, just to kind of reflect back what you were saying. So again, with the Private Express Trust doesn't have contact with the public, but it does have, out of that arises separate entities, what are called special purpose vehicles, which do interact with the public, but then the trusts have private contracts with each other, I guess, which would allow, the flow of exchange to occur, if you will.
Though simplified, that's the gist of it. Yes, you have a private entity, you have an interfacing or pass-through entity, and you have a public entity, and these are common things that can be researched all day long. I mean, even the IRS website explains these things clearly. So none of this that we're doing we're not reinventing the wheel here. We're just uncovering what most people don't fully understand, and we're putting it in a way that's malleable and understandable and that can be easily capacitated. We want to provide this information clearly and concisely, and allow people to really grasp it and use it. I feel that that's something else that really distinguishes us from the rest. Is I feel that there's a lot of scientific method, a lot of theory that goes into remedy. We're looking to form the strongest base of fundamental education that allows people to operate from their own power. And that's very important.